Hello and welcome to Legal Basics with Sarah Law Global, and my name is Tian. Today we begin the first episode of season 2 of the Employment Law series. As you've seen, all our previous series have only had one season, but for this one, because we've had a lot of response and a lot of questions, we decided that those questions could not just be answered in summary, so we decided to have a season 2 and possibly even a season 3. So welcome to season 2. Part of the feedback that we have received from you is that you want us to quote more sections of the law and you want us to quote more cases. And as we said, we're listening to you and your feedback is extremely valuable to us. So as you will see in season 2, we will give more specific legal provisions. We will refer to specific legal cases so that you're able, in your revision or in your research, you're able to find it. So part of the questions, or the bulk of questions that came from season 1 were questions regarding probationary contracts. The season 1 just did a very small broadcast on what the Employment Act provides in regards to probation. The fact that in Kenya, a probation term is 6 months long, which can be extended to another term of 6 months. And then if a person is to terminate that contract, whether it is the employer or the employee, then they only give a 1 week notice. Remember, this is very different from the termination of a person who is confirmed in an unlimited term of contract, because then they have to give a notice as per their contract. And if the contract does not mention, then they have to give a minimum of 28 days, which is either the employer or the employee. So for the employer, they give the employee a notice so that the employee is ready for their circumstances to change. And for the employee, you give notice to the employer when you want to go so that they're able to replace you or to change things around the workplace now that you're no longer here. So today we're going to deal with some of the questions that came in from season 1, and specifically on this episode we're going to deal with the questions that came from the probation broadcast. And also because since that broadcast, the law might have changed a little bit, but we'll find out in the broadcast. So one of the questions from Elvis asks whether confirmation automatically alters the terms of the contract, for example, remuneration. Now, as far as remuneration goes, some contracts provide a different amount of salary when a person is on probation and when a person is not. Now, what the law provides is that if there's a probation as part of the contract and there's been no communication in between the employer and the employee, and that time lapses, then automatically all the terms that would have been given to the employee once they are confirmed, then they start to run. For instance, there's the case. And now that you said you want more cases, so there's a case on Kashindi Digest, which is on page 85, and the case is between Gishuki Kabukuru versus Postal Corporation of Kenya. And in that case, the employee just kept working. So your probation period has ended, but you've kept working. And in this specific case, the claimant wanted the terms that had been promised to him upon confirmation to start to apply. And the court did decide that a probationary contract automatically converts into a confirmed employment at the end of the probation period unless it has been terminated. Now, Eric Mudao asked, what happens if an employee on probation approaches the court for a claim of unfair termination? I'm so happy that this question was asked during this period, because the answer I would have given him at the first broadcast is a different answer from the one we're going to give today. Just in August of 2021, the court declared a part of the Employment Act that regards how to terminate a probationary contract by an employee to be unconstitutional. So let's just go into the details. So in the case of Monica Munira and others versus Mount Kenya University, the claimants had been hired by now the university, and their probation period was going to go between the 1st of February to the 30th of April. And then on the 29th of April, just before, a day before their probationary period was going to end, they were terminated. And part of the reason was that they had been investigated, and the employer had felt that they had not been hired correctly. So when they went to court and they challenged the process in which they had been terminated, the employer had actually given them more than the statutory notice period of seven days, more than a week. So classically in employment, during the notice period, an employer who is letting go of an employee either lets them work and then compensates them for that week that the Act expects them to pay, expects them to give them in terms of notice, or they let them go immediately and pay them in lieu of notice. So in this particular situation, the employer actually paid them 14 days in lieu of notice, which was above the statutory limit at that time. Now, when they went, they said that they had been unfairly terminated because they had been investigated. They had not been called to respond to whatever this investigation had unearthed. And the employee came to court and said, you know what, you are under probation, and probation does not expect me to put you through a due disciplinary process. So in a regular termination, as you can remember from our previous episode on termination and on the disciplinary process, if an employee terminates the contract, then the employee only gives notice. And if the employer then is the one to terminate, then the employer has to put the employee through due process. And due process, first of all, they need to have a valid and a fair reason for termination, and they need to have put them through the due process, which includes giving the employee an opportunity to respond to the reasons why they want to let them go. Now, Section 41 of the Employment Act shows what an employer should do so that the termination process is procedural. However, Section 42, subsection 1 of the same Employment Act has specifically excluded probationary contracts from having to go through the due process that is provided for under Section 41. So when these claimants went to court, they challenged that section, and they said, much as it was according to the law, it is supposed to be unconstitutional because the Constitution provides under Article 41, it provides for employment rights. Under Article 47, it provides for fair administrative action, which includes giving people an opportunity to respond and being reasonable when giving an administrative decision. So the court actually found that even though a person is under probation, there is no reason to let go of this person without taking them through the due process of termination. And if people on probationary contracts were to get less favorable terms than the rest of the employees, then it would definitely amount to a discrimination, and this would be unconstitutional. So that was in response to Eric Mudau's question. I hope we have answered you. If we haven't, please let us know that we haven't answered you sufficiently. And if you have any questions for us regarding our Season 1 topics and the topics that we'll be covering in Season 2, remember to write to us at info@cyroglobal.com. That's info@cyroglobal.com. Or you can also write to us through our old Gmail address, that's cyroglobal@gmail.com. We appreciate that you've been sticking with us, that you've been sharing our videos, that you have subscribed. And now, before we close our broadcast, we would like to say our heartfelt thanks to Mushiri Frames, who is our videography crew. They will display their address on the screen, and to J. Ojuma Advocates, who have facilitated the shooting of this Season 2. Thank you so much for being with us. Bye-bye.